In this bulletin, a US court has advised Lexmark continues to prevent consumers from having choice with what they do with their empty printer cartridges. Hello, I'm David Gibbons and here is the news. Cartridge remanufacturers in the US have filed a friend of the court briefing to convince judges of the importance of a fair and open marketplace for imaging supplies. The International Imaging Technology Council, also called the I-ITC, which represents cartridge remanufacturers, wants to influence a case currently being heard at the US Court of Appeals for the Federal Circuit. In that case, Lexmark International is appealing an earlier decision by the District Court that its prebate program is not enforceable under patent law. A prebate is the same as a patent license that stops purchasers from having their empty used cartridges remanufactured or recycled by anyone but Lexmark. I-ITC Executive Director Tricia Judge says such a patent license or prebate on new cartridge buyers thwarts competition. She also says decision makers at all levels of the government need to know the importance of remanufacturing industries. The I-ITC brief alerts the judges, all appointed by the US President, and government decision makers that remanufacturing contributes to the economy and job market. Remanufacturing also has a pro-competitive effect on pricing and product availability, and it has a beneficial impact on the environment. The brief also argues that Lexmark's interpretation of the law is a threat to the consumer's right to repair its property and promotes anti-competitive behaviour. The attorney who won the earlier decision against Lexmark at the District Court is confident Lexmark will not win the appeal, and Ed O'Connor joins me online. Mr O'Connor, how significant will it be for remanufacturers if the US Court of Appeals for the Federal Circuit rejects Lexmark's appeal and upholds the decision you managed to get at the District Court?
The District Court's decision was essentially that Lexmark's prebate program is unenforceable under patent law because it attempts to restrict the use by purchasers of products that are sold in the normal course of commerce.
Ed, I assume the outcome of the case before the US Court of the Appeals for the Federal Circuit has serious implications for all remanufacturing industries, not just print consumables.
This decision, if it's upheld, will have enormous impact on a number of industries because of the breadth of the decision.
Yes, in fact, two automotive aftermarket associations have also joined in the I-ITC brief, the Automotive Aftermarket Industry Association and the Automotive Parts Remanufacturers Association. Thanks, Ed O'Connor. And Ed will be also updating remanufacturers at a summit meeting on January 15 in Barcelona, and you can go online to get tickets. And for more breaking legal news updates, visit iRecyclingTimes.com. See you tomorrow with more breaking news. I'm David Gibbons.